May it please the court, Your Honor?
You may proceed. Yes, sir.
Thank you, Judge. The defense kept on saying this is an accident and this is a mistake. Brooke in Justice on July 19th gave a perfectly healthy baby, Araya, to this defendant to care for, who made an agreement that she would care for her. 5 hours later, Araya is dead. This isn't a mistake. It isn't an accident. I had mentioned before that you will not see the word forget or I forgot or prospective memory error in the jury instructions, and you won't. The defense keeps on saying she forgot. As I said before, and I'll say it again, there are still consequences for your actions. One should still be held responsible. This defendant should still be held responsible for the death of Araya. Araya was in her care. The baby died. It's plain and simple. I was listening to what the defense was saying, writing notes. Once again, go with your notes. But it seems everyone is responsible for the death of Araya but the defendant. So let's go through this. One of the things I heard was Araya wasn't making noises to trigger the defendant's memory. So I guess it's Araya's fault that she didn't make noises. Next, Brooke's fault. She put the baby bag and Araya in the back of the seat. I guess Brooke could have put the baby in the front seat or the baby bag in the front seat. So we'll blame Brooke for the baby's death. Next, we talk about multitasking, that the defendant had so many things going on. One child's going to college, they're going to England, she's got all these things going on, so we're going to blame multitasking as the third reason as to why Araya is dead. Next, it seems to be my fault. I pressured her when I was asking her questions yesterday. And so as she was admitting to things, it suggested that I pressured her to answer them that way. So I guess it's my fault at this point. Next, we talk about a change in routine, because it wasn't normal that she would pick Araya up on that day or Stacy's kids on that day. So we're going to say it's a change in routine. That's why Araya is dead. I could go down the list of reasons that were given. There is one reason why Araya is dead, because she failed in her duty to care for her. Call it a mistake, it isn't a mistake. Say she forgot, that doesn't justify what she did. It isn't an excuse for what she did. Araya is dead because of...
May we approach?
We keep on talking about the word culpable negligence. We'll read part of it again. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause the death of the victim in this case. This defendant engaged in a course of conduct that she should have known would cause the death of Araya. It's that plain and simple. And as I said last time, every person has the duty to act reasonably towards others. If they violate that duty without a conscious intent to harm, there's still negligence. They still violated it. So it's a course of conduct or consciously doing something. I don't have to show both.
Your Honor, objection. May we approach again?
No. Sit down, please. Have a seat. You can make your argument from there. What is your argument?
My argument is that the state's mischaracterizing the law and discussing negligence instead of explaining culpable negligence to the jury.
Your response?
I am actually reading, Your Honor, from
The instructions.
definitions that are part of the jury instructions.
I think the problem is he's not giving the entire context of that sentence, Your Honor.
Okay, the jury will note that he's only reading a portion of the definition. I will read the entire definition to you, and you will have that definition later. But he's making a point, apparently, with respect to that. Carry on, sir.
Thank you, Your Honor. Defense had mentioned about gross and flagrant. That is also part of the definition of culpable negligence. If the death of a 10-month-old child who's been left in a vehicle for 5 hours isn't gross and flagrant, the state doesn't know what would be considered gross and flagrant. This is gross and flagrant. This shows a reckless disregard of human life. Also part of the definition of culpable negligence that the court will read to you. It must be gross and flagrant. It must show a reckless disregard of human life and for the safety of other people, including Araya's safety. That's part of the definition of culpable negligence. The court will read to you the entire definition and listen to the entire thing because it fits. What the defendant did is completely culpable negligence. It satisfies count one completely. Something else that the defense mentioned. The defense mentioned the child probably died in 20 or 30 minutes. The child is dead. Whether the child died in 20 or 30 minutes or 4 hours, Araya is dead. Does it make it better that it's in 20 or 30 minutes? Does that somehow excuse this behavior? Araya was in a hot car. What we know is her temperature went up to at least 133 degrees because the car went up to 133 degrees. Her brain was swelling, her organs stopped working, and she died. Whether it's 20 or 30 minutes, or 1 hour, or 2 hours, or 5 hours, the point is Araya is dead. The course of conduct, some of the things that we can point to is the defendant had a duty here. The defendant drove to Brooke's house. The defendant was present when Brooke put Araya in there, in the baby bag in the car. There is a course of conduct here. The defendant then went to Burger King and decided to leave. Her next course of conduct was to go to Stacy's house. Her next conduct was to get out of the car with all these items, except for the baby. There is a course of conduct here where she knew or should have known that Araya was in the car. Something else the defense mentioned about the defendant remembered when Brooke was at the door and had money in her hand. Please go with your memory. The defendant said Brooke had money in her hand. The state doesn't remember Brooke ever saying anything like that. Go with your memory, but the state does not remember Brooke testifying to that. Defense also mentioned about the defendant urinating on herself, vomiting. There could be a lot of reasons for that. One of them is because a child was in her care and the child is now dead. Forgetting a child in a car is not a defense or an excuse for this. saying it's an accident or accidents happen. I am sorry. I promised you I would take care of your child, and I forgot. Child's dead. It doesn't work that way. There are repercussions for something that drastic when something like that happens. Defense mentioned a few times that the defendant and the victim's family, I believe, were very close. That has nothing to do with this case. Has nothing to do with this case. Has nothing to do with July 19th. The fact is, yeah, I guess they knew the defendant. But she didn't care for Araya, meaning she didn't take care of her on July 19th. I said, and the defense agreed with me on this, you will never see prospective memory error on the jury instructions. It's not there. You are still held responsible, and there are still consequences. The defense mentioned, and I'm going to repeat it, that Dr. Cahill says he doesn't even know if the defendant suffered from prospective memory error. He can't even say that she had this. He has no clue. He's just telling you what it is. She may not even have suffered from this thing called prospective memory error, which is a fancy way of saying people forget things. The defense mentioned she didn't, this is semantics. The defense said she didn't leave the child in the car. She forgot the child in the car. Look, count 3 is very clear. I don't need to prove intent. And the state has made it very clear. On count 1, we're saying culpable negligence. We're not saying intent. I don't need to prove she intended to do anything. Count 2, I was very specific to say third-degree felony murder, not premeditated. And what the state means by that is we're not saying she meant to do it. We're not saying she intended to do it. And then count 3, the same thing. I don't need to prove any intent, and I've never alleged she intended to do it. But we're not going to play word games here and say leaving is not the same as forgetting. She didn't leave the child in the car for 5 hours. She forgot the child in the car for 5 hours. The statute is clear. If you leave a child in a car for 5 hours, unsupervised, over 15 minutes, and something bad happens, you're guilty. She left the child in a car. I'll just very briefly say that defense had talked about her demeanor on the video. I'm going to ask you to judge her demeanor. It's been an hour and a half, which to the state that isn't a lot of time. An hour and a half later, she's giving an interview. You judge her demeanor. An hour and a half after she realized that a child in her care is now dead. Prospective memory error. Do you need to remember to care for a child when you pick them up from the parent's house? Ms. Johnson mentioned about my driving example, that you make a conscious decision to drive. She made a conscious decision to care for Araya. She was getting paid money. She picked her up on certain days. She drove there that day. She had Araya put in the car, the baby bag put in the car. She made a decision to care for Araya on that day, and she didn't. Once again, when you go back into that jury room, look at all the evidence. I've put some evidence on. The defense has put some evidence on. You as jurors have to look at everything, not just the state's evidence, the defense evidence as well. We are asking you for count 1 to find her guilty of aggravated manslaughter of a child. Araya is dead because of her culpable negligence. Then for count 3, I like to switch it, leaving a child in a car for over 15 minutes, resulting in death. She's guilty of it. And once again, we're not saying she did this on purpose. That doesn't matter here. We're not arguing intent. And then for number 2, third-degree felony murder child in the car for over 15 minutes, 5 hours actually, and the child died because of her actions or inactions for not caring for that child. So once again, I ask you to find her guilty on all 3 counts. Thank you.
Members of the jury, we have some rather lengthy jury instructions that I'm going to have to read to you. So before we do that, we're going to go ahead and take about a 15-minute recess so you can stand up, stretch, and be ready for the instructions. So we are in recess.